Swayam Prabha. Digital India. Educated India.
Hello friends, this is the 11th lecture under the course The Law Relating to Women and Children. This 11th lecture relates to the topic the status of women under personal laws. Our country is very diverse country and India recognizes the customs, usages, etc. as the law, which is evident under the section 13. If we see the definition of law, it includes the customs and usages also. Everybody is free in India to follow or to adopt the community customs relating to personal matters. But sometimes we see that under different personal laws, some practices or some customs are derogatory to the women, or they are amounting to the violation of right to equality entitled to women. Unequal treatment with women in personal laws is a problem. India is a secular country, and in this secular country, though everybody is allowed, permitted to adopt the practices of his own personal law, but at the same time, we are also to see that the constitutional mandate provides for the right to equality to everybody, irrespective of his sex, irrespective of his place of birth, irrespective of his residence, irrespective of his religion. So, on the basis of the religion, on the basis of sex, the discrimination cannot be made in men and women, and therefore, the state is obliged under this constitutional mandate to provide for the legal regime to protect the right to equality and right to dignity of women, so that in the name of the practices or the customs of personal laws, the women may not be denigrated, the right to equality of women may not be compromised, and therefore, this issue, the status of the woman under personal law, becomes very significant. It is the duty of the state to find out such discriminatory practices in different personal laws and to provide for the law to eradicate these discriminatory practices or derogatory practices to women. Under this topic of lecture 11, that is the status of women under personal law, we are to see that what is the position of the women under different personal laws and what is the international law and the national law in India with regard to the status of women under personal laws. Friends, India is a secular nation and recognizes customs and usages as law by virtue of Article 13 of Indian Constitution. We have very diverse demography, and the people, they belong to different religion, they follow distinct faith, belief and the practices. Personal laws include the laws relating to marriage, divorce, inheritance, adoption, maintenance, etc. Personal laws are intricate part of an individual's life and provide a sense of connection with the religion and community to which that person belongs. But we see that the few provisions of different personal laws are proven to be more outdated than ancient, which are violative of principle of equality, and this has prompted central government to take initiatives for adopting uniform civil code in near future, as mentioned in Article 44 of Indian Constitution. This is the constitutional mandate, and this duty has been imposed on the state through the directive principles of state policy, that is Article 44, that the India should come up with the uniform civil code, so that such instances of inequality, instances of discrimination, instances of unreasonableness, instances of derogation because of some practices in different personal laws may be avoided. India is the secular nation, and it provides liberty to citizens who do not wish to be governed by their personal laws to govern by secular legislations like Special Marriage Act, Indian Succession Act, Indian Divorce Act, etc. So, on one hand, the Indian legal system permits everybody to adopt the personal law, but if anybody is not willing to adopt the practices of personal law, then the secular legislations like Special Marriage Act 1954, Indian Succession Act 1955 and Indian Divorce Act 1869 have been enacted by Indian legislature. It is also significant to note that the state of Goa has successfully implemented uniform civil code to address the issue of gender discrimination in different personal laws. Recently, the state of Uttarakhand has also adopted uniform civil code with a view to provide for regime of equality for men and women of all the religions with respect to laws of marriage, divorce, adoption, inheritance. If we see the international mandate with regard to the status of women, we find the Universal Declaration of Human Rights 1949. Article 18 of UDHR provides that every person has the right to freedom of thought, conscience and religion. This includes freedom to adopt the religion or belief. Everyone has the right to manifest the teachings, practices, worship and observance of the religion or belief of their own choice. So, without any discrimination on the basis of sex, everybody is allowed by Article 18 of Universal Declaration of Human Rights to adopt the religion or to adopt any belief. Everybody has the right to manifest the teachings of his or her own religion, to practice her or his own religion, to worship and to observe the religious beliefs of his or her own choice. If we see Declaration on the Elimination of all forms of intolerance and of discrimination based on religion or belief 1981, Article 1, Clause 3 provides that freedom to manifest one's religion or belief is subject to legal limitations, also public safety, order, health, morals, fundamental rights and freedoms of others. You can see the relation or the connection in Article 18 of Universal Declaration of Human Rights and Article 1(3) of Declaration on the elimination of all forms of intolerance and of discrimination based on religion or belief 1981. The Universal Declaration of Human Rights gives the guarantee to everybody, gives the freedom to everybody to follow his or her own religion, to practice, propagate the religious practices of his or her own choice, one. But it has also been mentioned under Article 1 clause 3 of this declaration, that this freedom to manifest one's religion or belief is subject to legal limitations, or these legal limitations may be public safety, public order, public health, morals, fundamental rights and freedom of others. So, everybody is entitled to follow and propagate his or her own religion or religious practices, but this freedom to follow and propagate his own religious beliefs or religious practices is subject to legal limitations, is subject to the fundamental rights of others, it is subject to public safety, it is subject to public health, it is subject to public morals. It means that nobody is allowed to this freedom of religion or the freedom to adopt and follow and propagate the religious practices which are derogatory to, which are infringing to, which are violative to the fundamental rights of others. And this combination or this connection in these two provisions of international law provides for the sound foundation for developing the law by the nations to protect the women from such kind of discriminations or such kind of derogations being made to them by the religious or the religious practices or the provisions of personal laws. If we see the constitutional mandate in India, Article 13 of Part 3 provides that laws which are inconsistent with the fundamental rights would be called void. If any law which is inconsistent with the fundamental rights, either it is existing law or it is the law being made by the legislature. Both the laws, if these are found inconsistent with the fundamental rights, these are void to the extent of their inconsistency with fundamental rights. It means, or now see the definition of law under Article 13, clause 3. This definition of law includes the legislation being enacted by the legislatures. This definition of law, the meaning of law includes the customs, usages, and we know that the personal laws are based on such customs and usages. In each and every personal law, mostly the part of the personal law which has not been enacted yet, it is always based on the customs and usages of that particular religion or that particular community. So, if any such custom or any such practice which is though religious practice or which is though granted in a particular religion or community, but if it is found violative of, it is found inconsistent with the fundamental rights, it cannot sustain. You can understand it by taking illustration of one important source of Hindu law. In Hindu law, there are two kind of sources, ancient sources and the modern sources. Within ancient sources, the Srutis, that is Vedas, the Smritis, digest and commentaries, then customs and usages are the primary source. In India, for any custom to be valid, there are certain requirements. Under these requirements, one requirement is that that custom must not be unconstitutional, or in other words or positively, the every custom must be constitutional. So, if any custom or any uses, it is inconsistent with the constitutional provisions, if it is inconsistent with any constitutional principle, it cannot sustain and it is always void. But personal laws are put out of the purview of this definition of law, and therefore, despite many discrepancies with fundamental rights, these personal laws cannot be held void. Though the customs and usages, if these are inconsistent with fundamental rights, are void, but this has also been one approach that personal laws are out of the scope of, or they are beyond the scope of Article 13, and therefore, even if there are certain discrepancies in these personal laws, some provisions of personal laws may be violative of the constitutional principle and constitutional provisions, they cannot be held void. Now see Article 14. This fundamental right in the form of Article 14 in Part 3 of our Constitution provide every person, though irrespective of the fact that if he is the citizen of India or not, this fundamental right is guaranteed to everybody, every person, citizens and non-citizens also. Equality before law and equal protection of laws. Everybody, every person is entitled to equality before law, and every person is entitled equal protection of laws. This provision becomes bedrock for ensuring equality in personal laws that are violative of Article 14. When every person is entitled to equal protection of laws, every person is entitled to equality before law, then in the name of personal laws, the inequality, the discrimination, the unreasonableness, the arbitrariness cannot be caused to anybody. Article 15 further expands the scope of Article 14. The Article 14 is the general provision, it provides for the equality before law to everybody, every person, and the equal protection of laws to every person. And the Article 15 provides that there shall not be any kind of discrimination on the basis of sex, on the basis of religion, on the basis of place of residence, etc. Now, if we see Article 15 clause 1 and Article 15 clause 2, we find that nobody can be discriminated on the basis of sex, nobody can be discriminated on the basis of religion. On the other hand, there is Article 15 clause 3. Within Article 15, the clause 3 provides that the state can make, or nothing in clause 1 and clause 2 of Article 15 shall prevent the state to make the special provisions for women and children. We can understand that our constitution makers, they were very well aware of the denigrating status of women in India from very ancient period. The women, they were deprived of the equality, they were treated with discrimination and unreasonableness, they were deprived of the property rights, they were deprived of the educational rights, they were deprived of the social, cultural and religious rights. And therefore, the constitution makers, they enabled the state to make the special provisions to protect the women from such kind of discrimination, unreasonableness and inequality. It means that the affirmative action can be made in favor of, though Article 14 and Article 15 both imposes the obligation on the state or the government that it cannot discriminate on the ground of sex, but Article 15 clause 3 gives the authority to the state to make the affirmative discrimination, to make or to provide for the positive discrimination in favor of women if such a requirement is filled. You can also refer Article 14 of our Constitution. This article is a part of directive principles of state policy, and Article 14 dictates that state should be inclined to bring uniform civil code throughout India for all its citizens. This has been adopted by 2 states till now, Goa and Uttarakhand. When the constitution makers, they included this provision in the constitution, the constitutional debate indicates that they were aware of the fact of the discriminatory provisions of different personal laws, and therefore they were very cautious, they were very careful about the protection of women against such kind of discriminatory instances, discriminatory practices in personal laws, and therefore they were of the opinion that a uniform civil code should be evolved in India to treat the women with equality, or the persons or the individuals of all the religions, particularly the men and women, with equality. If we see the national legislative action or national legislative initiatives in India with regard to the personal laws or with regard to the status of women under personal laws, we can divide it into different classes, like different aspects of the personal laws like marriage, divorce, adoption and succession. These are the different domains of aspects of the personal laws, and we are to see that in different personal laws with regard to these different domains, these different aspects of personal law, what is the status of women and what kind of discriminations are being made against the women. In 1955, the Hindu marriage law was codified when the Hindu Marriage Act was enacted. This Hindu Marriage Act 1955 positions both men and women on equal footing by providing similar marital rights and imposing equal obligations. If we see Hindu law of marriage contained in the Hindu Marriage Act 1955, there is no discrimination on the basis of sex. The men and women both are treated equally, or both are treated on equal footing. In Hindu community also, the polygamy was in practice, and this polygamy was prohibited by section 5 of the Hindu Marriage Act. It makes the marriage null and void. So, polygamy has been prohibited. This is also one step forward with regard to the equal rights to women and men. Section 5 lays down conditions for marriage which require both the parties, bride and bridegroom, or their guardians, to have capacity to render consent for marriage. This is the condition precedent for valid marriage, that a free and valid consent must be there on the part of both the parties. And therefore, the age of marriage was set out, or it was fixed more than the age of majority. Section 9 of the Hindu Marriage Act provides for restitution of conjugal rights, where one spouse is out of the company of the other. Then the deprived spouse can claim the restitution of conjugal rights before the court of law. Here also there is no discrimination on the basis of sex. The men and women both are the bride and bridegroom. The men and women, both the parties of the marriage, are equally entitled for this remedy of restitution of conjugal rights under section 9. If we see section 12C of the Act, it dictates that if marriage is concluded in violation of free consent, that is by fraud or force, such marriage would be voidable. So, if the free consent has not been obtained in solemnizing the marriage, this marriage is voidable. Section 8 recognizes the registration of marriage as a proof of marriage, which was later held by the Supreme Court in Seema versus Ashwani Kumar to make registration of marriage compulsory irrespective of religion. We know that there are many instances where even after the marriage, the women are left by the husbands, the wives, they are treated in very ill manner, in very bad manner, and they are sent out of the home. And therefore, the proof of marriage, that is the registration, may be an important initiative towards protecting the rights or the status of women in the institution of marriage. Section 15 of the Hindu Marriage Act provides for right to get remarried after divorce. The position of divorcee, particularly the divorced women, was very miserable in India. There was a time when the divorced wives or divorced women, they were not entitled to get remarried, but section 15 provides for right to get remarried after divorce. Muslim personal laws, if we see the Muslim personal laws, recognize and validate polygamous marriages, that is up to the 4 wives. So, polygamy is permitted there. Itna Asariya School of Shia law recognizes muta marriage, which literally translates to marriage for enjoyment. Here marriage is contracted for a particular amount of time. So, this practice is also not good for the status of women. Muslim male can marry any non-Muslim without changing his religion, but Muslim female is not allowed to marry non-Muslims, non-Muslim males. Again, we find the instance of discrimination or inequality. Under Muslim personal laws, such marriage would be void if any Muslim woman marriages with non-Muslim male, then the marriage will be void. But if the Muslim male marriages with any non-Muslim female, that marriage would not be a void marriage. She can marry with non-Muslim male under Special Marriage Act 1956, but under Muslim personal law, she cannot marry with a non-Muslim. Then would be governed by Indian Succession Act and not by her personal laws. So, if any Muslim woman she marriages with any non-Muslim male, she is not entitled to get the property rights under the personal law. She can marry under the Special Marriage Act and she can have the property rights under Indian Succession Act. If a Parsi woman marries a non-Parsi, in Parsi law, if a Parsi woman marries a non-Parsi, then she will follow the husband's faith, and children born out of marriage will be brought up as the faith husband wishes for. Such children will have no right of property as per Parsi law. This is the position of marriage in these 3 different personal laws. Then come to the divorce. Marriage under Hindu law is considered as a sacrament. The marriage under the Hindu law is not considered to be the contract, it is considered to be the sacrament. Hence, dissolution of marriage was not a practiced and accepted notion. The divorce or the dissolution of marriage was not the practiced and accepted notion in Hindu law, but the Hindu Marriage Act 1955 positions both men and women on equal footing by providing similar marital rights and imposing equal obligations, and gave divorce rights to both men and women as per section 13 of Hindu Marriage Act. Lack of free consent in Muslim marriage makes the marriage void. Marriage under Muslim law is not a sacrament, but it is considered to be the civil contract, and therefore the consent, free consent, because it is the contract, the free consent of both the parties, it becomes relevant for valid marriage or for the validation of marriage. Age of marriage in Muslim personal laws is the age of puberty. and any marriage contracted with the consent of the guardian of such minor can be held rectified if the minor choose the option of puberty upon attaining majority. Divorce is recognized under Muslim personal law, but provisions are different for men and women. Presence of wife at the time of pronouncement of talaq is not necessary. For the validity of talaq, notice to wife is not necessary. We can understand it by taking it into two parts: status of woman in instance of divorce by husband. When the husband takes the divorce, he has unrestricted rights to pronounce talaq without any reason. Talaqul sunnat is an approved form of talaq because of revocable nature. Talaqul biddat is disapproved from form of talaq and only recognized by Sunni law. This is commonly known as triple talaq, talaqul biddat, which was made illegal by the Supreme Court in 2017, and the Union legislature has also been enacted, declaring the triple talaq as an offence punishable under the Act. Then see the status of women in instances of divorce by wife. Wife has the right to khula. Wife has limited right of divorce in Muslim personal law in the form of khula, but she can offer khula to husband to release him from matrimonial obligations, but this offer must be accepted by husband. Though she has the option of khula, but that khula may be realized only when such offer is accepted by the husband. Until and unless this offer is not accepted by the Muslim husband, the talaq is not complete, given on the part of the woman. Under the Dissolution of Muslim Marriage Act 1939, this law was enacted in 1939. Section 2 provides for ground of divorce available to wife. This enactment provides for the ground on which the wife can take the divorce. Number 1, husband being missing for 4 years, husband's failure to maintain wife for 2 years, husband is jailed for 7 years, husband's failure to consummate the marriage for 3 years, impotency of husband, insanity of husband, leprosy or venereal disease of husband, option of puberty to wife or cruelty by the husband. If husband renounces Islam under section 4 of Dissolution of Marriage Act, marriage is dissolved immediately, but if wife renounces Islam, she has to obtain decree of divorce under section 2. Even after renouncing the Islam, she is under the obligations of the marriage until she obtains the decree of divorce. In the matter of succession, in Hindu law, there was the concept of Stridhan. That Stridhan means all offerings or gifts which the bride gets before or after the Hindu marriage ceremonies, and these gifts or offerings would be considered her sole property under the concept of Stridhan, and she would have absolute authority over the Stridhan. The Hindu Law of Inheritance Amendment Act 1929 made a modification in the traditional law of inheritance relating to son's daughter, daughter's daughter, sister and sister's son. The Hindu Women's Right to Property Act 1937 made an improvement in relation to the legal position of women regarding inheritance of property, being survivors of male Hindus under the law of succession and joint family. Section 6 of Hindu Succession Act 1956 deals with the devolution of interest in co-partitionary property. Co-partitionary property means the joint Hindu family property. And this section 6 is also known as notional partition. Amendment of 2005 gave equal right to work to both men and women. Before this, the co-partitionary right was solely available to male. Before 2005, in co-partitionary properties, the girls or women, they had no right to property, only the male on the basis of survivorship they had the right. This section 6 deals with the transfer of property in joint Hindu family governed by Mitakshara law. Amendment of 2005 added these 4 as class 1 here: son of the predeceased daughter, of a predeceased daughter, daughter of a predeceased daughter, of a predeceased daughter, daughter of a predeceased son, of a predeceased daughter, and daughter of a predeceased daughter of a predeceased son. So, daughters are given the right in co-partitionary properties, and they were when the class 1, they have also been made the class 1 here. Section 14 says that property of a female Hindu to be her absolute property. This section also deals with Stridhan. So, the property of a female Hindu and the property under the Stridhan has been made the absolute property of the female. Section 15 deals with general rule of succession in case of female heirs. Section 16 deals with order of succession and manner of distribution among heirs of female Hindu. Section 31 to 49 of Indian Succession Act 1925 are applicable to Jews and Christians. Christians of Travancore and Cochin are regulated by their own succession laws. If the father dies intestate, the widow will get 1/3 share in the property, and the remaining property will be shared among sons and daughters equally as per section 33. So, section 33 provides that if any father dies intestate, then the widow of that person will get 1/3 share of the total property, and from the remaining property the share of daughters and sons would be made. If there are no offsprings of the deceased father, then widow will receive the whole share in the property. Such an arrangement was made to provide the share in the property to the widows and to the women. If a Parsi woman marries a non-Parsi, she will follow the husband's faith, and children born out of marriage will be brought up as the faith husband wishes for. Such children will have no right of the property as per Parsi law. Women in Muslim personal laws have significant property rights. Daughters are primary heirs and inherit in one of the two capacities. When we study the law of inheritance, it is said that the Muslim law of inheritance seems to be very scientific law of inheritance. Daughter's share is half of the son's, and she holds complete authority over the property. Under this law, the mothers get 1/3 of the son's property in case when son has no children, and 1/6 of the son's property when the son have the children. So, mothers get 1/3 of the son's property in case son has no children, and 1/6 of the son's property when the son have the children. Maternal grandmothers get 1/6 of the share in case there is no mother or the grandmother. Maintenance is also one aspect of the personal laws, and it is very closely connected to the status of women. The issue of maintenance is very sensitive issue, as we know that the economic reliance of the women on their husbands or their family has been the rule. They were not economically independent. Even today we see that in most of the families in our country, the women, if they have their own earnings, they are economically very weak. So, the issue of maintenance, it directly connected to the issue of the status of women, and therefore, it is also very relevant to be taken into consideration when we discuss the status of women under different personal laws. What is the position of maintenance? See, women in Hindu law have maintenance rights under section 24 and 25 of Hindu Marriage Act. As alimony for wife and under section 18 and 19 in Hindu Adoption and Maintenance Act 1956 for wife and widowed daughter-in-law. So, we can understand it into two parts, section 24 and 25 of Hindu Marriage Act, where the women have maintenance rights as alimony, and section 18 and section 19 in Hindu Adoption and Maintenance Act, where the wives and widowed daughter, they have the maintenance rights. Women under Muslim personal laws have the right to get maintenance, that is dower, and even in muta marriage, woman is liable to receive the dower. The woman is entitled to receive the dower. Wife have following remedies in case of non-payment of order. These remedies are right to refusal to cohabit. This right has been given to the Muslim woman, that if the dower is not given, then she has the right to refusal to cohabit. Right to dower as debt. She has the right of dower as the debt. Right to retention or possessory right. So, she always possess, she always retain the right to dower. Right to maintenance under section 125 of Code of Criminal Procedure 1973, and this section 125 of Code of Criminal Procedure, which relates to the maintenance, now it is replaced by section 144 of Bharatiya Nagarik Suraksha Sanhita 2023. This section 25 of CRPC or section 144 of BNSA is a secular law providing for maintenance to every woman irrespective of any religion or faith. This is the secular law, this is the secular provision, it is out of the religious norms, and here every woman has the right to maintenance, every woman has the right to maintenance irrespective of her religion. Then see the judicial approach. We have discussed the provisions under the personal laws, uncodified personal laws, the practices and customs, and also the codified portion of the different personal laws. We have seen that what has been the status of women and what is the status of women with regard to the marital rights, with regard to the right as to divorce, with regard to the right of maintenance. Then if we see the judicial approach, Ahmedabad Women Action Group versus Union of India. This case was decided in 1997, and this is the case which is one among many cases where the Supreme Court on the issue of personal laws being violative of fundamental rights of equality held that this matter need to be addressed by the legislature as it is policy matter and court should not interfere. We know that in India the courts or the judiciary shows very firm attitude or the approach towards the doctrine of separation of powers. And in several cases decided by the Supreme Court of India, the Supreme Court did not intervene or it refrained from intervening in policy matters, in political issues. Policy matter belongs directly to the legislature if this is the matter of legislative policy, and if it is the matter of executive policy, then it exclusively belongs to the executive. And the judiciary has been of the approach that the judiciary will not intervene in policy matter until and unless there is any ground of illegality in that policy. there are different cases where the Supreme Court has held that the policy matter exclusively belong to the legislature, and the court cannot direct the legislature to make or not to make or unmake any legislative policy or any law. In the same line, the Supreme Court in the case of Ahmedabad Women Action Group versus Union of India observed that if there are any instances of inequality, discrimination, etc., in the provisions of personal laws, in the practices or customs of personal laws, then these are to be dealt with by the legislature, and the court cannot intervene in these matters because these matters belong to the legislative policy. Then John Balamattan versus Union of India, this case was decided by the Supreme Court in 2003. In this case, the Supreme Court provided that Article 44 establishes that there is no necessary connection between religion and personal laws, and a clear demarcation between the two can be made. Many times the Supreme Court has expressed its opinion that there are many such aspects of the personal laws. There are several instances which do not intricately or inherently belong to the religious practices. These are the secular aspects of the personal laws, and these secular aspects of personal laws can be regulated by the law. So, you can see the approach in the change or the difference in the approach of the Supreme Court in 1997 in the case of Ahmedabad Women Action Group and in 2003 in the case of John Balamattan versus Union of India case. The Supreme Court says that Article 44, which is a part of Part 3 of Indian Constitution in the form of one directive to the state to be included in its policies, that there is no necessary connection between religion and personal laws, and a clear demarcation between these two can be made. It means that the several aspects of personal laws which are not integral part of religious practices, which are not very closely connected with the religious practices, these can be remedied, these can be tackled with, these can be dealt with, these can be regulated by the law to be made by the legislature. In Avadhes versus Union of India 1994, a PIL was filed. PIL means the public interest litigation. The Supreme Court rejected the plea to declare the Muslim Women's Protection of Rights on Divorce Act 1986 as void, contending it as a policy matter again and better dealt by the legislature. We know that this enactment in the name of Muslim Women's Protection of Rights on Divorce Act 1986 was enacted by the then Congress government headed by the then Prime Minister Mr. Rajiv Gandhi, and the then government came with the proposal bill in the Lok Sabha, in the Parliament, to enact this law for altering the decision of the Supreme Court in Saira Banu case. This enactment of this legislation was very much criticized at that time, but the Supreme Court has its own limitations. The Supreme Court cannot hold such a law being enacted by the legislature as void because of the reason that it belongs to the policy matters and the legislature can deal with this matter. In S. Vijay Kumari case, which was decided recently in 2024, the Supreme Court held that Domestic Violence Act 2005 is such a civil code which is applicable to every woman in India irrespective of the religious affiliation or belief. The enactment of the Domestic Violence Act, the Protection of Women from Domestic Violence Act 2005, it has also been very significant initiative on the part of legislature to protect the women against domestic violence. Domestic violence is also one important instance which is denigrating to the woman or which is responsible for lowering down the status of the woman in family, in society. There are two aspects. Domestic violence against the woman are caused or practiced also because of the same reason, because of the consideration that the status of women is lower than, inferior than men, and it also gives rise to lowering down the status of women in the family, the status of women in the society. So, if we see such a situation where we find the discrimination in different personal laws, we can see that, or we can realize that there is a need to make the reforms in these personal laws. If the Uniform Civil Code cannot be enacted, then for a time being the piecemeal reforms may be made in different personal laws and discriminatory practices to the women may be addressed. In the case of Kapoor Chand versus Kedar Nisa, which was decided in 1953, the Supreme Court held that unpaid dower would be considered as an unpaid debt in the eyes of laws. It also gives the right to the Muslim women to have the dower. Shaira Banu versus Union of India 2017, the Supreme Court in by 3:2 majority gave the landmark judgment declaring the practice of instant talaq or triple talaq or talaq-e-biddat as unconstitutional and as violative of Article 14 and 21 of Indian Constitution. It shows the approach, changing approach of the judiciary, that the provisions or the practices or the customs being adopted, being followed in different personal laws which are grossly violative of Article 14 and 21 are considered to be unconstitutional and invalid by the court. It seems that the court now is ready to declare such instances of discrimination and violation of right to life and personal liberty of the women in personal laws as derogatory, as invalid and unconstitutional. This 2017 decision in Shaira Banu case gives the opportunity to the legislature to enact the law, to amend the situation or to protect the women against such discrimination and to protect their right to equality and right to life and liberty. The enactment was made and this triple talaq was declared to be invalid by the legislation in India. So, as a conclusion, we can say that under different personal laws, though we could not deal with all the different aspects in very detail because of the limitation of time, in one lecture itself the contents of all the personal laws was to be covered. So, by these instances which we included in today's discussion, we can understand that still there are different provisions or different practices or customs in personal laws which are derogatory to the women, which are discriminatory to the women, which are amounting to be the violative of right to life and personal liberty of women, and therefore, there is a need for ameliorating the situation, for improving the situation, for protecting the rights of women and to uplift the status of women in the society and in the family. And it is also one important aspect because the matter of personal laws is very sensitive. It directly relates to the sentiments of the people belonging to particular religion or the community, and therefore, only the law cannot be the way out or only the law cannot be the medium to improve the situation. There is a need for the society to understand the situation of the women or deprivation which is being made with the women, and women should be respected, their rights and their status should be uplifted, their rights should be protected, so that their status in the society and family may be protected. Thank you very much.
Hello, good morning everybody. I am Raghunandan Sengupta. So, I will just give you a very brief excitement area of finance, which is quantitative finance, and that has a huge market starting around about 10 years back, and it is exploding exponentially. So, what do we mean by quantitative finance? Quantitative finance is actually the application of different mathematical and statistical techniques in the area of financial markets, be it say for example derivative pricing, be it in the area of say for example portfolio management, be it in the area of asset liability management, be it in the area of portfolio management. We see that the application has exploded in such a way that there is a huge opportunity for people who have a quantitative background in mathematics and statistics. They can utilize those in the area of finance, but obviously with some prior knowledge of finance as a subject. Now, when we say about quantitative finance, as I said, it is an area of applied mathematics and statistics applied in financial markets. Use of different areas, if somebody is interested to know, we have stochastic calculus, we have derivative pricing, we have operation research, we have quantitative techniques like differential equations, stochastic calculus, time series, and they are heavily used in the area of quantitative finance as I mentioned. Now, we all know that in 1997 the Nobel Prize in Economics, so it is basically the Nobel Memorial Prize in Economics was given to the work of Merton and Scholz in the area of derivative pricing, and after that there has been exponential increase in the area of quantitative techniques in quantitative finance and in the area of different type of derivative pricing. With the advent, moreover with the advent of high-ended and sophisticated computing data, big data has come in a very big way, where application areas starting from computing, from different type of algorithm design have been taken up in such a big way that nowadays at least we are able to understand that how high frequency data algorithm trading can be utilized using the concept of quantitative finance in the area of finance as such. But there is a flip side also, obviously when there is a huge amount of development. So, obviously due to some regulation errors or something, there has been some pitfalls, which I think is should be a bullet point for people who are really interested to take up quantitative finance. They should be aware. So, consider the financial crisis in 2008 and later on, and we are seeing different banks are failing, different financial institutions are facing a problem, countries are facing a problem like in Europe, in USA. So, what should be done? So, the main thing is that even if you know the technique is best for people who are investors, who are private players, organizations like banks, governments should use these techniques in a very somber manner, such that the application areas of quantitative finance using the techniques which we learned can be utilized in the best possible way to garner the overall the in-depth knowledge a person has in trying to utilize these quantitative techniques in finance. And I am sure that people who have the background, who have the knowledge, who have the sophistication, who have the knowledge of the society can definitely use quantitative finance in a very big way in trying to make their mark in this exciting field, which you are going to see in years to come. And I am sure it will be a very exciting learning tool for all the participants who will take quantitative finance as a subject in years to come. Thank you, and I wish all the participants all the best and best of luck for the programs they will take. Thank you.